Wow, what an opening statement there by the prosecution. I'm here right now with criminal defense attorney and former federal prosecutor Gene Rossi. Gene, quite the opening statement, quite the case. Looking for your reaction right now.
You know, whenever you see objections during an opening statement, either by the prosecution or by the defense, it always brings tension to the courtroom because it's the beginning of the trial. They swore in the jury, and you're not expecting fireworks so soon. I think what happened was the prosecutor was engaging in argument in opening, which you can't do in opening. You're only allowed to tell the jury what the evidence will show. You can't inject your opinion of what the evidence had been presented to the jury, what inferences were from that evidence. So this is why I love trials. You can't prepare in law school for getting an objection during your opening. And I think the prosecutor handled it pretty well. And
the judge apparently gave some leeway there, mostly from what I heard, mostly overruling those objections. But let's see how the prosecutor did in the opening statement. So if anybody's just joining us, this is some of that really, well, yes, you could call it controversial opening statement. Let's take a look.
It's the state's position that we will prove the charge beyond all reasonable doubt as outlined by the court of the indictment of aggravated murder with the specification of a firearm. This case is more complicated than most. As you are aware, we will present evidence of flight by the defendant, Claudia Hoerig. We have a case that happened, a crime that was committed on March 12, 2007. She fled to Brazil. In fact, the evidence will show in her long statement on videotape that's been admitted for your review and will be played when this man, Detective Mike Yanucci, who was at the crime scene, that she was guilty and that she should serve a sentence in Brazil to be close to her family. Objection, Your Honor.
Ladies and gentlemen of the jury, and overrule that. These are statements of counsel. These are not evidence. Please proceed.
All right, so that was some of the opening statement from earlier today. Gene, let's talk about Brazil. She had been there for years, and there was a fight back and forth about whether or not she'd even be allowed to be extradited back to the U.S., and unfortunately for her, in 2016, the Supreme Court of Brazil basically said, hey, she's all yours, America, take her back, and that's what happened. Can you explain a little bit about how this happened? Because we never see this really in these kind of trials.
Well, first off, there's one way you can extradite somebody. If you promise to the country that you're not going to seek the death penalty, we had a defendant in one of our law and crime shows that was extradited, I think, from Mexico or another country, if we promise not to seek the death penalty. What I think happened in Brazil is she may have violated the terms of her presence in Brazil that caused the authorities to say, you know what? We don't think you deserve to be a citizen anymore. Once that happened, the cloak of protection that she once had was removed, and then the extradition treaty kicked in.
Yeah, well, it was interesting because the prosecutors here argued that in 1999 she became a naturalized U.S. citizen, renounced her Brazilian citizenship. It was a fight there. In the 2016, the Brazilian Supreme Court actually revoked her Brazilian citizenship, and she was arrested. It took about a year for her to get transferred back here to the U.S., and it's amazing to see this trial going underway. Let's continue on with a little bit more of the prosecution's opening statement from earlier today.
She was guilty of the aggravated murder of her husband. and that she should be tried and serve time for that crime in Brazil and serve 30 years. That's what she said. You will hear it. What is the importance of her statements? As the judge has indicated, you're going to decide for yourself what to believe that's true or not true. I'm just telling you what you're going to get is words from her mouth over a 2.5-hour period. And this man will testify it's the longest statement he's ever taken. But that statement was taken in 2018, January 17th. A long journey from the time Major Hoerig, who was a 43-year-old veteran who spent most of his life serving the United States Air Force and serving the people of this country in the defense of this country.
So, Gene, one of the biggest things is going to be the statements from, or the alleged statements from the defendant, apparently where she confessed to the killing, but the prosecutor said it's not exactly the way she said it. I'm curious your thoughts about her alleged confession.
Well, here's the thing about confessions. They don't have to be inculpatory statements. They don't have to be things that's where the defendant says, I did it. To me, a statement by a defendant can be devastating if they say something that's inconsistent with the forensic or documentary evidence, and also if they make a series of statements that are inconsistent. You know, the light was red, the light was green, then it was red. That's devastating also. So you won't hear her say, I murdered my husband, it was premeditated, you got me. But what they're going to do is use those statements on inconsistencies and also the blatant self-serving, what I call exculpatory statements.
I still can't get over the statement that she apparently made where she said she shot him because he didn't really care that she was going to kill herself, and all he said was, well, if you're going to kill yourself, make sure to do it in the basement so no blood gets anywhere. Gene, we're going to talk about that statement. Let's take a quick break. We'll be right back. Already so much to talk about in this brand new trial here on Law and Crime. All right, Gene, if you're sitting in the defense, you're just waiting to jump in there with your opening statement after hearing what the prosecution had to say. So what would you argue as the defense attorney in the opening statement?
I would argue, members of the jury, that Claudia Hoerig was in an abusive marriage. And it's very sad, and we have sympathy for Major Carl Hoerig. But what you have to learn is what the prosecutor said is just what he thinks the evidence is going to show. Here's what we think it's going to show. She had no way out of that marriage. She was willing to take her life. And you may, during the listening to this testimony, disagree with the actions that she took, but she was a desperate person in a desperate marriage. And it wasn't premeditated. It wasn't calculated. She acted out of heat of passion, and sadly her husband was killed. That's what I'd say.
Well, we're going to have to see if this is what they argue, Gene, and that was very well said. Now, Gene, I'm going to be signing off, but don't worry, you're on with the great Bob Bianchi, who's coming up next, so stand by. We are covering a lot here on the network, multiple live trials, and again, we do expect to be live in California in the McStay family murder case, but we're also waiting to be back live in the Ohio v. Claudia Hoerig case. We want to see what the defense is going to argue after objecting so much for the prosecution's opening statement. So you know what I'm going to say. Stay tuned here on Law and Crime. We'll be right back.
Welcome back to the Law&Crime Network. My name is Bob Bianchi, and I'm going to be taking this from 12:30 to 4 o'clock. We got a lot on our plate today. Hey, thanks to all you guys who are watching us across all of our amazing platforms that we have. And if you've been watching, get into that chat room. I'd love to be able to answer some of your questions. I'm in there right now. And hello to all those normal chatters. Guys, listen, we got a couple of things in here. Tomorrow, the Monell case, that's the New Jersey, my home state case. That murder case will be continuing, as well as the Hoerig trial that we had today that we started. It's a fascinating case, and that is on break right now. And let's look at this McStay case, because we think this is the case that keeps on giving in terms of factual issues, legal issues, very well thought out by both the prosecution and the defense. I have my good friend that I'll be bringing on shortly, Gene Rossi, who's going to be following through with it. But there was a really interesting development yesterday. If you've been watching our commentary, you know we've been talking a lot about the police work in the case. And one of those officers was a Detective Troy Dougal. And I think that you need to really listen. Remember, one of the responding officers thought something was remiss and thought something was not right. Something was odd. So they called the homicide squad, even though it was just a missing persons case at that point in time. And they came out with cadaver dogs. Listen carefully to what they did and didn't do.
Backing up to the search of the house, why didn't you ask that the cadaver dogs be brought into the house?
There were no signs of, we had no signs of criminal activity in the house that we recognized. Cadaver dogs are going to, once again, look for decomposition. Decomposition is when the body is decomposing over days. I had no indication that there were remains in the house, so we didn't enter the dogs into the house.
Did you tear up any carpet, do anything like that at the house?
No. Part of the search process is obviously to look for a crime scene, to find evidence of a crime, and we did not. And once you find evidence of a crime, if you find evidence of a crime, you can dig deeper. You can do more chemical testing. You can tear carpet up. You can cut walls out if you need to. But just in general, if you just go in and you look around and it looks normal, we don't cut walls and pull carpet. We just don't. That's not a traditional search, especially in a missing persons case.
Okay, so let me bring my hashtag 4041 in. Gene Rossi, DOJ, 3 decades. He's a legal analyst here at the Law&Crime Network. He's got his own radio show, trained over 1,000 prosecutors, prolific trial career. Gene, welcome back.
Always good to be back.
Yeah. So, Gene, listen, you know, we're kind of piggybacking on from when we were here on Monday. This is a detective that's on the stand and talking about all the things that you would do inside of a crime scene, inside of a home, in order to gather evidence, in order to try to solve and prosecute the offender. None of that was done here.
Well, Bob, we kind of talked about it Monday. This is not the perfectly investigated crime. They kind of dropped the ball on determining that there was a possible homicide of the entire family. So in terms of starting the investigation, they were weeks, if not months, behind the curve. And that could have led to some of the hiccups and holes that apparently exist in the prosecution's case.
Right, and you know, judges will read jury instructions at the end of the case, Gene. You actually had 2 prosecution witnesses. One was a friend of the family who saw mom cleaning up the leftover food in the kitchen and said to himself, oh, I don't think that's a good idea. But the cops had said you can go in there and clean up. And then you had this astute officer who sees that a whole family is missing, thinks it's odd, calls the homicide squad, and they really don't go in there and process. In fact, they don't process the scene at all. And at the end of the case, Gene, as you know, the judge can say you could find them not guilty for failure to do something that they should have done. And that can be very hurtful to the prosecution, despite the fact we all know no case is 100% perfect.
Right. And if I'm the defense attorney, I'm old school. I will take that jury instruction, Bob, and I will hold it up and I will read it to the jury and just flash that so that when they go into that jury box, deliberation room, they're focusing like a laser beam on that very strongly worded instructions for the defense.
Right. Okay. Listen, I've had sloppy investigative work that I've had to work myself through as a prosecutor. Gene, I know you have too. This is pretty significant, but the prosecution still got fight in this game, and the prosecutors are clearly very, very skilled. Let's listen a little bit more of what Detective Dougal said. Okay, so that's Detective Dougal. Gene, Rossi, cross-examination is happening here. I want to take a step back a little bit with this idea that they couldn't get into the house without a search warrant. So, one, I'm wondering whether they would be able to get a search warrant or at least try to make an application to get a search warrant. You certainly would try under these circumstances. Two, if the family wasn't there, there could be somebody else that may be able to give permission for them to go in there. And three, if you can't get any of that, you might as well go in. And at the end of the day, if it gets suppressed, it gets suppressed. It's better than not having it at all.
Yeah, I don't want to go to option 3 because that would be
no, but if you Gene, what I mean by that, just to be clear, is option 3 is better than option 4, do nothing.
I agree, but options 1 and 2 are fabulous. And here's the thing: if you go to a judge and say that we're investigating the murder of a family, a wife, a husband, and 2 young kids, there is no judge on the planet that's going to deny that search warrant. You would need probably the barest minimum of probable cause. But you know what bothers me a little bit about this investigation? I know the detective has a lot of experience and he spoke from the heart. And he said that I didn't go to the shopping mall to see if they had any video because they don't keep it. My view is you cross every T, dot every I. What if they did keep it? We had a murder, a local murder, triple murder here in Alexandria. They went to Target and they got a clip of 5 seconds that Target had kept for like 2 years.
There you go, Gene. You sloppy, sloppy, sloppy. Let's see if it ultimately affects the case. We got to go to break. We'll be right back. Hey, Gene, so what do you think about these speaking objections in the courtroom and these prosecution being overwhelmed by being overruled by over-objecting?
Whenever the prosecution makes objections that are overruled, seriatim, that shows incredible weakness. That's point number 1. And Bob, you were a prosecutor. I only objected if it was really, really important. Some of these objections are petty.
Right.
Picayune.
Yeah, agreed, Gene, completely. Let's go back to court.
Those voicemails?
I'm just going to take a little sidebar here with Gene Rossi because I saw from my side monitor when I brought up a lawyer who asked a why question, Gene's body kind of gyrated a little bit. Gene, I know they say never ask a question you don't necessarily know the answer to or ask a why question. I don't agree with that philosophy, especially if you hem a guy in and know that you can get an answer like, I don't know why I didn't do it. What do you think?
Yeah. There's a trial attorney named Stern. He wrote a book called Tiger in the Courtroom, and he said that sometimes it's best to ask a why question because, you know, when you're cross-examining, you're going to get an answer like, I don't know. Here's why I shook a little bit. I oftentimes had the why question on cross when I was a prosecutor, and I always objected because the motives of the officers are not necessarily relevant to the elements of the crime. However, in this case, it may be because confirmation bias. If he didn't look and pursue the Brett Kavanaugh angle, it supports the theory there was confirmation bias, that they were going after Chase Merritt. They didn't want to hear about evidence relating to Kavanaugh. That's why they didn't follow certain leads.
Amen. We talked about that confirmation bias a lot on Monday. You can all check that out, but we got to go back to court. All right, that's the defense opening in a Hoerig case. Gene, let's just go through some broad strokes. They're not contesting that she is the person who shot and killed her husband, and she was basically trying to commit suicide, according to him, had an actual suicide rigged up thing. She goes into the bathroom, puts a gun to her head. She wants him to see this, I guess, in order to initiate a discussion. And he basically said, go to the basement and shoot yourself there because he didn't want to get blood in the bathroom. and enraged, that's the word the defense lawyer used, he shot him in the back and knew that that shot was the shot that killed him. So I assume, Gene, what's going on is a passion provocation defense or whatever their equivalency is in Ohio. And just so our audience knows, and this law is pretty common throughout the country, the provocation has to be reasonable. The individual, in fact, needed to be provoked. And typically speaking, there needs to be no cooling off period. And in fact, the person did not cool off. Now, it always comes down, Gene Rossi, to a reasonable person standard. I think this is a tough passion provocation case because I don't think the jurors are going to find it's reasonable that if the guy says that you shoot him. You can be mad, you can be angry, but that doesn't suffice to meet the hard burden for the defense of passion provocation. Your thoughts?
Well, it depends on what happened before the day of that murder. If the jury finds out that there may possibly have been abuse, there may not be, but if there was abuse and maltreatment by the husband against the wife, even though that moment of provocation wasn't what a normal person may have been reacting to, they may cut the defendant a break. In Virginia, we had 2 state cases involving provocation. One was the famous Lorena Bobbitt case, where she cut off the private area of her husband, and the provocation really wasn't much, but she had been through a series of abusive events. Then there was a lady in horse country where she shot her husband, and I think that case ended up with second degree or manslaughter. So this defense could possibly sway the jury either to acquit or to find a lesser included.
Right, Gene, a very good point. All those things are very true. And, of course, jury psychology, if they do believe that she was a victim of abuse. It'd be interesting to see, Gene, if they get doctors and experts to testify in this case on behalf of the defense. But we will await for that. We have to go to a quick break. As you guys know, we got a lot going on. Please stick with us. And if you can, get into the chat room. That's where I'm going right now. Okay, we just got done listening to the defense opening statement. Just some quick highlights. He's really trying to point out there that prior to this date of an incident, that she did not, quote unquote, premeditate. Now, we all know premeditation can be formed in an instant. Nevertheless, he's saying it's not planned. She gave money to her dad out there in Brazil. She then starts to, afterward, look for in the computer for flights to Brazil. She goes to the bank to get her passport. Nothing plans, leaves her clothing, put the gun back in the suicide rig that she had. All of this to presuppose that she would not have, she didn't think about doing this prior to this. Gene, I know a lot of people in the chat room are all over this on both sides of the equation as to whether or not this will suffice to bring out a mitigation or a defense of passion provocation. But I kind of found it interesting that they said that there was a little bit of a struggle, I believe, over the gun. And at one point he says, go ahead and do it. Just go down in the basement. This is a military guy. Military guys take weapons very seriously. Do you suppose that when he sees an irate spouse of his, when they're having such problems, that he would allow her to continue to be in control of a gun when she's in that state?
Absolutely not. He's a major in the Air Force, and if he sees his wife, even though they may not have the perfect marriage, and she has a gun pointed at her head, I'm sure first thing he's going to try to do is grab that gun and get it away from her as soon as possible. I did want to say about the defense opening that, you know what, if you're a defense attorney, it's like poker. You're dealt a hand. He's doing the best he can with the cards that are dealt him. And, the post-murder or shooting events going on the computer, that does seem to suggest that there wasn't a high level of premeditation, because if she really did premeditate, she would have had her bags packed, she would have had a car ready, she would have had a flight ready. So that was a good point that he made. I want to compliment the defense attorney.
Yeah, and we talk about this a lot, Gene. Like the defense attorney took advantage of the opening statement, laid it out to the jury. They are the cards he was dealt. He's going to play them, hopefully, like we always say, Gene, right? It only takes one to hang a jury, or maybe something less than murder. Once again, Law&Crime Network is picking the perfect trial because there are arguments on both sides of the fence. We got a lot going on, folks. We're going to take a quick break, and we'll be back with more Law and Crime. Okay, we're in the Claudia Hoerig case here. This has been a blockbuster witness, Brian Martin. And you know what? Me and Gene Rossi just can't do it all. We need to get some other heavy hitters on the show with us. So I got Marnie Jo Snyder with me. She practices out of Philly and in New Jersey, former public defender, has tried thousands of cases from misdemeanor bench trials, jury trials, and state and federal court. Marnie, welcome.
Thanks for having me.
Yeah, awesome. So listen, this witness brought out, I'm just interested in your thoughts on this, that she actually had him modify the weapon by putting a laser grip on it, which shoots out a beam of light towards its intended target. Gene and myself both think that that is a pretty damning piece of evidence in a case where the defense is arguing she got the gun for purposes of suicide, not murder. What do you think?
Yeah, I mean, that definitely hurts the suicide version of things. Luckily, I don't think that it precludes an argument of self-defense. I think that the argument would be that she's not as familiar with guns and that she's trying to get one for self-defense. She needs to make sure that she's not dangerous with it. But it certainly, to me, ruins any sort of suicide argument. I think that the defense better think on their toes and think of a different way to spin this.
Gene, I want to thank you for spending an extra hour with me. You got about 20 seconds. Any final thoughts?
I totally agree with Marnie. I think it does get rid of the suicide defense, but they still have an argument that it is self-defense.
Okay. Hey, Gene, I want to thank you so much as always. I'll hopefully be seeing you back next Monday when I'm hosting. Marnie will be staying with me. We're in the Claudia Hoerig case. It's a fascinating case already, only on the Law and Crime Network. We'll be right back.